Court of Appeal. We have two cases on the docket this afternoon. The first one is Samuel Pitts versus the state of Florida. 15 minutes per side. Mr. Efferman, are you ready? Please proceed.
Good afternoon. May it please the court, Michael Efferman on behalf of the appellant, Sam Pitts. I'd like to reserve 5 minutes of my time for rebuttal. The issue in this case concerns whether or not the trial court erred by allowing in Williams Rule evidence. And there's 4 arguments relating to the Williams Rule evidence that are addressed in the briefs. I'm hoping to touch upon each of those arguments this afternoon. I'll start with the first one, which concerns notice. The information in this case was filed in 2012, but the state's Williams Rule notice was not filed until June 3rd, 2016, which was exactly 10 days before the jury selection proceeding was supposed to take place, which it did take place on June 13th. So when the state filed their Williams Rule notice, they put in the notice the specific purposes for which they intended to introduce the Williams Rule evidence. And I'm quoting from page 384 of the record. The state wanted to, quote, prove a material fact and issue, specifically the requisite element of intent, including absence of mistake or modus operandi. After the state filed its Williams Rule notice, the defense filed a motion in limine in this case, and I've reviewed a number of records over the years. This is one of the most extensive motions in limine I've ever seen in response to a Williams Rule notice. It's 25 pages, and the defense goes through point by point why, for these 3 purposes, the Williams Rule evidence would not be admissible. Now, because the state didn't file their notice until right at the 10-day deadline, the trial court did not have an opportunity to address this prior to trial. So after the jury was selected and after the trial began, the court held a Williams Rule hearing in trial. And during the Williams Rule hearing, the state argued that the Williams Rule evidence was admissible for these 3 purposes. The defense argued that it was not. And the trial court, for the first time after the trial had begun and after the parties had already presented their argument, said, I think I agree with you, defense. It doesn't come in for any of these 3 reasons, but I think it comes in for a completely separate reason. It comes in for propensity. The court.
So is there any requirement to put in your Williams Rule notice what the purpose, what category of Williams Rule?
Yes, and in fact, so when it got brought up at trial, the judge asked that question, and commendably, the prosecutor herself pointed to Professor Earhart and said, it's Professor Earhart that says that the better view is you must put the purpose into the notice. And let me quote from Professor Earhart. He says, the better view is to require the notice to include the purpose the evidence will be offered to prove so as to enable the defense to prepare to meet the prosecution's evidence. The notice enables the defendant to prepare a rebuttal to this evidence prior to trial. That notice opportunity, that due process opportunity, was completely taken away in this case.
So
And
where is that?
Go ahead, Judge.
Where is that requirement in the plain language of the statute?
The plain language of statute says that notice must be given 10 days ahead of time. So I think when to give full effect to the purpose of this, Professor Earhart and the 4th ECA in the Zenobia case have said that the notice must include the purpose. And the reason is just for what happened in this case. The defense spent hours putting together a 25-page memo responding to each of these 3 reasons pre-trial. That was all wasted when the judge for the first time at trial says actually it can come in for a completely different reason. And there's a real practical purpose as to why it must be pre-trial. And that's because you may decide, a defendant may decide, not to even proceed the trial depending on how strong the state's Williams Rule evidence might be. I've got a handful of post-conviction cases right now that involve, I was prepared to go to trial, but I chose to enter a plea at the last second because my attorney advised me that the state's Williams Rule evidence would come in. And you can imagine that if the defense attorney is advising the client, look, the state's Williams Rule evidence is strong. Once the jury hears that, you're probably going to be convicted. It's best to let's try to work on a plea deal with the state, or perhaps enter a straight-up plea. Or I think the Williams Rule evidence is weak. I don't think it's going to come in, and we can go to trial, and that's going to stay out, and then you can beat this charge because we know the case law talks about how prejudicial Williams Rule evidence can be once it's introduced. In this case, my client was completely deprived of that opportunity. The state told the defense the 3 reasons it thought it was going to come in. The defense responded to those 3 reasons. The defense was right. It didn't come in for any of those 3 reasons. And now for the first time in the middle of the trial, the defense is being told, oh, but it's going to come in for a completely different reason. At that point, it's too late to consider any plea discussions, any open plea. You're already in the middle of the trial.
So Zenobia is your case on point.
And the learned Professor Earhart that makes it very clear that the better
but
view.
he gets that from Zenobia. He didn't make that up, obviously.
Well, no, I disagree. He says the better view. So
Yeah.
he's acknowledging there's 2 views, and he's
Yeah.
giving his opinion, which I don't think Professor Earhart does very often, but he did here.
You're
Better
correct.
view.
I think that is interesting. He gave his view, but the other DCAs have largely not followed Zenobia.
And one of them in particular, Professor Earhart points out that actually the Kirkland case from the second DCA just last year, what they did file was sufficient to put the defense on notice as to what the purpose was. So even though they said they disagreed with Zenobia, they went on to say, nevertheless, even in this case, what was filed sufficiently put the defense on notice regarding the purpose. The other case was the fifth DCA case, and in passing, they simply said, we disagree because they go beyond what the statute requires.
Are there any other cases other than those three that are addressed in the briefs that talk about this?
Or I'm not aware of any other cases other than those three cases and Professor Earhart's opinion on it. So for that reason alone, I think the Williams rule evidence was improperly admitted into this case because there's a notice problem. But let me move on to 2 and 3 real quick. 2 and 3 I'll address together. As the court is aware, in 2011, well, let me back up. When Williams rule was decided in Florida by the Florida Supreme Court initially in the Williams case, the initial rule was that you can allow in, the state can introduce Williams rule evidence when it meets one of these particular purposes to show motive, intent, absence of mistake. However, the rule at that time was Williams rule evidence is not admissible solely to show propensity or bad character.
But you agree that's not the rule.
Well, the legislature carved out an exception years later, and
Right.
the first exception dealt with only child molestation cases. And I think the reason for that was the legislature recognized that alleged victims in child molestation cases are vulnerable victims. It's not easy for them to portray the facts regarding what allegedly occurred. So therefore, in that very small subset of cases, we will allow in Williams rule evidence solely to show propensity if it's a child molestation case. And then in 2011, the legislature expanded that to include all sex offenses, including sex offenses involving an adult alleged victim. No DCA has said that Williams rule evidence is admissible for propensity only in cases involving an adult alleged victim.
But none has said it's.
Yeah, I think that's my question as well. Go ahead.
No DCA has ruled on it. It's not, or at least if it's come up, no DCA has written on that issue.
I want to make sure I understand your argument correctly, because you seem to be making an argument that under the statute, even propensity wouldn't be allowed, and then it seems like you're making a separate argument, and maybe it's an alternative argument, that if that is what the statute says, then the statute's unconstitutional. It violates due process. I mean,
Well,
help me understand.
sure.
Does it fit into this? Does it fit into the statute? And if not, why not?
The plain language of 9404 prior to 2011
No,
was it's not allowed in for propensity purposes.
Right.
After 2011, now there's a part that says it's not allowed in for propensity, but under, I think, 2C, it goes on to say unless it's a sex offense, and then it's allowed in for any purpose whatsoever. So the statute does allow it in now. It makes an
Okay,
exception.
so that's that. Okay.
And so, but no court has ruled on whether or not the statute violates a defendant's constitutional rights. So if you go back to the purpose of Williams rule to begin with, the courts have said repeatedly that there's a problem with allowing Williams rule evidence in, certainly if it's only to show propensities, because a defendant should be charged and the jury should consider the evidence based only on what's in the charging document. They should not base their decision on bad character from years ago, because it's likely that they'll say if you allegedly did something bad years ago, you probably did it in this case, even if the evidence is not sufficient in this case.
But didn't the Florida Supreme Court address that with respect to 2B in the McLean decision?
They did, but again, it's a very limited subset of child alleged victims, and I think it's very different when you're talking about an adult alleged victim. I've cited 2 cases that specifically held that propensity evidence cannot come in, but again, those are pre-2011 cases. Let me make
the takeaway from McLean that all that is cured by the balancing.
Well, I mean, well, so let's get it. Well, I think the bigger argument in that regard is this. If you're going to allow in propensity evidence for the state in a case involving an alleged adult victim,
You have to make sure that the defendant still has a fair trial, and you do that by applying the.
Well, no, I was going to say something different, Your Honor.
Okay, go ahead.
You have to make sure that the defendant, if he asks, can put in his own evidence of good character to respond to the bad character or reputation testimony.
But that's a separate issue, right? I mean, that's sort of the next issue. The first is whether this comes in at all. I mean, you've got a separate argument about whether some rebuttal.
Yes, no doubt, balancing under McLean applies to any Williams rule evidence case, and the judge is required to balance that evidence. The judge in this case said, I acknowledge it's extremely prejudicial, but that's the nature of Williams rule evidence. I'm not here arguing that it wouldn't otherwise meet the Williams rule standard. It's a very low standard for the state to put on evidence that this allegedly occurred. All the state has to put on is an alleged victim who says that, and that's generally going to be enough. So I can't argue that the initial prongs for the state to get through wouldn't have been met in this case. You get to a latter prong, which is addressing McLean, which is the fourth point in my brief, which it cannot become a feature of the trial. In this case, it clearly did. You had two witnesses talk about the details of the Williams rule evidence. In this case, only one witness talked about the charged offense, and I think that's clear, and the prosecution referenced it in closing. But I think, getting back to my third point, if you're going to allow in propensity evidence solely for the purpose of showing propensity in a case involving an adult alleged victim, the defense has to be able to respond to that with his own evidence of either good character or reputation. Judge Lewis struggled with this the most. He acknowledged as soon as defense counsel brought this up, he anticipated where defense counsel was going, and he said, I see where you're going, and in fact, I get it. What's good for the goose is good for the gander, and fairness would generally require you be able to do this, but you just can't. And he didn't cite a case to support his reasoning. He just said, you can't. You can't, and the defense proffered Rebecca O'Rear's testimony, who specifically said that she did date Mr. Pitts in high school, and he was in no way sexually aggressive or violent.
Was there other evidence that would be in that category of things that the defense wanted to put in rebuttal, or is it just the...
It's Ms. O'Rear's testimony, and when the argument was being made, and this is particular on page 376, defense counsel says if Mr. Pitt's reputation in high school was actually a reputation for nonviolence with respect to sexual offenses, that should be admissible to the jury. Judge Lewis's response, it just isn't. That's character evidence that you can't do by reputation. That's simply false. I've cited the Pino case that cites other cases. That was then Judge Grimes in the second DCA. The defense has every right to put in reputation evidence.
But was any evidence proffered? I mean, is there specific evidence we're talking about other than the young woman's testimony?
No, but that's the proffer. Well, it's 249 through 252. That was proffered, and defense counsel's argument that I want to put this in the form of reputation evidence that he had a good reputation, just as I read to you.
Okay, it's the same woman that was going to...
Yes.
That's the same point we're talking about. Okay.
So I submit defense counsel clearly argued, I want to put this in either as a specific act or reputation. Judge Lewis, as I just read to you, said you just can't. And Judge Lewis is wrong. He's wrong when it comes to reputation. Again, I cite to the Pino case. Judge Grimes specifically said, and I'll quote from it, the criminal defendant accused of assault or battery is entitled to introduce evidence of his lack of propensity toward violence. Just in a case like this, the criminal defendant accused of sexually aggressive offense should be permitted to put in evidence of his reputation for a lack of sexual aggressiveness. Certainly in a high school setting where the Williams rule evidence related to, you can imagine, and we all have been in high school or have kids and/or who have kids that have been in high school, if you get a reputation for being sexually aggressive in a relationship, that type of rumor would spread, and there would be a reputation in that regard. And the fact that the defense wanted to put on that he had a reputation for not having any type of sexual violence or aggressiveness, the defense had a right to do that. That would have been a right to do that regardless of the propensity evidence. I think beyond that, we know that under 9405, the statute generally says that the prosecution cannot put on evidence of a defendant's bad character. But once you're going to cross the bridge and now say that in these sexual offense cases the prosecution can do that, the defendant has to, under due process considerations, fairness considerations, have a right to put on his own evidence to refute the propensity testimony and say, look, you're putting on a specific example for the sole purpose of proving that because I did it then, I must have done it now. I should be able to put on my own testimony from someone else who said I didn't do it then, so I can argue to the jury I didn't do it in another situation, and therefore I didn't do it now. And again, Judge Lewis's words are the best. What's good for the goose is what's good for the gander. If this court is going to say Judge Lewis was right, we're going to be the first court to acknowledge, because maybe it hasn't come up in another case, that the 2011 statute is correct. Sex offenses, you're allowed to put in propensity evidence solely for propensity. However, when the defense wants to put on evidence of specific acts of good character to respond to that propensity evidence, it would be a complete violation of due process and fairness to prevent the defendant from doing so. Likewise, if the defendant wants to put on evidence of reputation, the defendant has a right to do so. And that wasn't allowed in this case, and I don't think there's any good reason, nothing the state cited in their answer brief, that would not have allowed that evidence in this case. And then the final point, I've already addressed it briefly, and I do want to reserve a minute of my time for a rebuttal, but this was a case where the Williams rule evidence became a feature. Again, I've already said it, you had two witnesses for the Williams rule, you only had one for the alleged offense. So the state cites to the police officer's testimony, he simply said he responded to the scene. There's no details about the offense that came in through him. You have the prosecution repeatedly referring to it in closing, and that's in any Williams rule case, regardless of whether it's propensity or not, you're simply not allowed to make the Williams rule evidence a feature. Judge Lewis himself was worried that he said, look, we've already spent 2 hours on this, how is it not becoming a feature? I'd ask this court to reverse. I'll reserve my remaining minute for rebuttal.
I'm going to give you an extra minute since part of that was caused by our question. And of course, the other side has an extra minute if they need to use it.
Thank you, Your Honor.
Thank you, Your Honor. Jason Rodriguez, Assistant Attorney General representing the state of Florida. In my time before the court, I'll explain why the trial court did not err in admitting the evidence at issue in this case. And really, predominantly, this case comes down to a very simple point, that even good ideas for improving a statute should be addressed to the legislature and not to this court. The notice provision that is required under the sexual offense statute is when the state in a criminal action intends to offer evidence of other criminal offenses under the paragraphs, no fewer than 10 days before trial, the state shall furnish the defendant or defendant's counsel a written statement of the acts or offenses it intends to offer, describing them with the particularity required in an indictment or information. There's simply nothing in the statute that requires the state to actually say we intend to utilize this evidence for this purpose. The fact that the state did so in this case and it was admitted for another reason is irrelevant because the state went above and beyond what the statute requires.
But why is that irrelevant? If the state is putting defense on notice that we're going to use this for purpose A, and then it ultimately deemed admissible for purpose B, why doesn't that cause some sort of due process concerns for the defense?
Simply because the state wasn't required to do so in any way, shape,
But
or
it did.
form.
So it took an affirmative obligation and arguably boxed itself in by pointing to a specific purpose. So again, where's to me, there's a due process consideration.
Well, Your Honor, I simply would, I think, disagree on that point. When we talk about the state going above and beyond in the trial court, certainly not bound to the simple arguments that the state would make.
Well, it's not above and beyond, right? I mean, they'd be better served if they just said nothing. I mean, the defense would be better served if the state said nothing than to offer something and then go a different direction. I mean, that's a fair observation.
Certainly, but I don't think the trial court was bound under the law to only consider the arguments that the state had brought forward. It was entitled to look at the entirety of the statute and say, well, maybe it doesn't come in for this purpose, but it can come in for this other purpose that you haven't cited. And because nothing required the state or limited the state legally, it was permitted to do that. And that's really what the case comes down to. I think it's important to note that Zenobia is dicta. That is not what the 4th District was writing about. They were writing, their primary ground for affirmance was to say the trial court's ruling was tentative. And they only wrote, according to their opinion, to address the dissent's point of view, which says nothing about the collateral crime evidence or the notice at all. So Zenobia is pure dicta, as opposed to the 2nd and 5th District courts, which have addressed this issue and said, look, you're reading in an element of the statute that's simply not there. And accordingly, I think that the notice argument, just from a legal perspective, is flawed. Regardless of the learned Professor Earhart's opinion on the matter. That might be a reason why the legislature should amend the statute to require that, but certainly it is not a requirement now. And this court, as it's held on multiple occasions, can't edit a statute to bring about a result thought better by the litigants or even someone as learned and esteemed as Professor Earhart. Moving to the second issue, I want to be very careful here because I'm not quite certain that I agree with defense counsel's reading of this statute or even the child abuse statute. The state's position is not that this comes in simply for the purposes of propensity, as in we say this can come in because he's a bad guy, he's done this and he's a bad guy and we want you to convict on that basis. That's propensity. What the Florida Supreme Court has done in McLean is say this can come in via corroboration to show that something similar happened to a different victim at a different point in time, and it's admissible to corroborate the victim's testimony. This isn't sheer propensity saying this is a bad guy and we should convict on that basis. And I've cited cases about the approved use of corroboration can slip very quickly into the impermissible use of propensity. So in an odd fashion, I think counsel for the appellant has a broader reading of the statute than even the state does. It comes in for corroboration, the fact that something similar happened to this other victim at a prior point in time, and the same thing happened to the victim in this case, or a very similar thing happened to the victim in this case. So that kind of frames, I think, the issue up front. And regarding the...
So if the circumstances of the two sexual assaults were different, you were saying it couldn't come in for corroboration. That would be pure propensity evidence, right?
Yes, Your Honor. And I think that's what McLean looks at. It looks at certain factors and says, we want trial courts to not only be limited to these factors, but consider these others to ensure, under a 403 analysis, that it's not just coming in so we can convict him on his evidence of bad character.
But you're not saying that 2C wouldn't allow that. You're saying 2C would sort of authorize it on the front end, but it would be not allowed on the back end.
Right, and I think we can look to federal courts which have held that propensity would be an admissible basis. But under McLean, it appears like the Florida Supreme Court has said, if we just are introducing it for propensity, that's per se going to fail the 403 analysis. And so the state has to give more than that. There has to be corroboration. And that's really what we're looking at in this case as well. Regarding the age, there's been an amended statute, and the statute doesn't focus on the age of the victim, it focuses on the sexual offense at issue. And so, sure, there have been courts that held to the contrary prior to the statutory amendment, but we have a different statute now, and appellant has really raised no reason why there should be a difference and why we shouldn't simply look to the plain language of the statute and apply the statute as is written. I think the Florida Supreme Court's analysis in McLean leads us to where the statute is not unconstitutional because of the 403 balancing test. And that's been the position of the federal courts in the 10th Circuit and NJ, one of the leading cases cited by the Florida Supreme Court, which held that the federal equivalent of this rule are not unconstitutional because of the 403 balancing test. So the age in this case is irrelevant because of the amended statute and the way that it's been amended. Another area that I think that, moving to his third argument, this idea of specific acts, I think that appellant and I disagree regarding what he was trying to offer at trial. It seems pretty clear from the proffer that he's trying to offer specific act testimony that he had never battered his former girlfriend. That's the way that I read his initial brief, and really the way that I read his reply brief as well. The argument was not at trial that he could not introduce evidence generally of reputation in a subset of the community. That would have been a different analysis. We'd have to look, well, is a particular high school big enough? It would have been a different argument. What he appeared to try to introduce at trial and what he proffered was his girlfriend's testimony, that she had not been battered by him, which would be a specific act. It's not permitted in Florida. We have cases like the 5th District case cited in my brief where you're not allowed to put in specific good conduct acts in order to prove character. We're looking for reputation. Even opinion is not permitted in Florida. We only look towards evidence of reputation. It has to be from a large enough subset of the community. So is a particular high school class large enough? That's an unbriefed issue before this court. It wasn't an issue that I was prepared for. It's not one that came up really below, and it wasn't one that came up in the briefs. So to the extent that that's being argued, I think it's being argued for the first time at oral argument, and as this court's well aware, that's a per se bar on that issue. What he introduced at trial and what appellant tried to bring in his brief was a specific act that he had not battered this person. And I think when we look at that in the first hand, it's just irrelevant. He could probably bring in 50 people he didn't batter. That's not the point. The state was bringing in evidence of corroboration of the victim's testimony to say, this is what you did here. You did something very similar in this particular case. So we're going to corroborate the victim's testimony via looking at the collateral crime as permissible under McLean rather. So he was not permitted, and Florida law is very clear. You cannot bring in specific acts of good conduct in a case like this, or in any case really. We're limited to evidence of reputation. And then the final argument that appellant makes is that this somehow became a feature of the trial, and appellant has reached this position mostly by counting witnesses. We have two for the state on the main crime, 2 for the collateral crime, but this court's inquiry is not counting witnesses. The Florida Supreme Court's made that clear, that collateral crime evidence is not impermissible merely because it's voluminous. The Florida Supreme Court has allowed evidence of 5 murders in the prosecution of the 6th murder. We're not just counting witnesses here. We're looking at the comparative relevance and seeing if the state's focus on it exceeded the bounds of what it was relevant to show. Here, the collateral crime evidence was exceedingly relevant because the main reason the state can't make a harmless argument in this case is because it did turn on, it was a he said, she said. And so it was exceedingly relevant to show corroboration of her testimony.
Would your analysis be different if the trial court found this as propensity evidence?
Your Honor, quite honestly, if the trial court had just said that it was propensity evidence, I'd be just focusing on tipsy coachman.
Well, then let's focus on tipsy. So is this your tipsy coachman argument then?
Well, I think this is what he actually did. He does use the term propensity, but he also used the term corroboration. So I think it's unfortunate that it appears that these terms have been used back and forth by defense below, defense here, and the trial court kind of interchangeably when they do speak to different ideas. But I think it's clear from, and I'll look at the language directly of what he says, but in his, let me see, it's page 190 of the, page 7 of the transcript. So how about the purpose of corroborating the victim's testimony, because there's obviously going to be a credibility issue, and the defendant asked, between the victim and the defendant asked what happened. And that's page 7 of the trial transcript. So he's using the term propensity. It's unfortunate that he's using
He says under the new code, propensity is a legitimate basis to introduce it.
Yes, Your Honor. And then if you look at the last part of that sentence, I think that's a transcript at 303, it says it corroborates the testimony of the victim that something similar happened to someone else. So It's
How is that not
unfortunate.
propensity? I mean, it's not corroborating by some specific detail or some, something unique about it. It's just, it's saying he had an opportunity to do this before, and he did it, and so that corroborates her version of events here, right?
No, Your Honor. I think it's a little bit more involved than that, and I think that the Florida Supreme Court's ruling in McLean really shows that. We're not just looking at you committed a sexual offense before. We're looking at similarity, and in this case, we had two individuals. They were kind of spur of the moment. One that was in the Bahamas that he waited until they were exceedingly drunk. He then digitally penetrated them and took advantage of that situation from an acquaintance standpoint. And that's similar enough. It's not just that he committed a sexual offense. We were dealing with one offense that was rape, penile and vaginal penetration, and one that was digital penetration. There'd be a question on whether that's similar enough to admit it. But it's that he did something exceedingly similar in the past to what he did here. And that hasn't been challenged either on appeal or at trial either. So we look at that, and then looking at the fact that the state, appellant has pointed out that the state referenced this in closing argument, but they referenced it and said he's not on trial for this. The trial court correctly instructed the jury he's not on trial for this. So the state was permitted to point this out in closing, but didn't make it a feature of the trial. Instead, they redirected the jury away from this, said you can take this into consideration, but you're here today to render a verdict on what he did to this particular victim. And so any argument, I think, that this has become a feature of the trial merely because it's voluminous is flawed via the Florida Supreme Court's test. And when we look at the particular facts of this case and what the state actually did and what the trial court did, the state didn't reference it in opening, only in closing. It becomes very clear that as the Florida Supreme Court defines this issue, it did not become an impermissible feature of the trial in any way, shape, or form. Your Honors, unless this court has any further questions for me, I'll yield the rest of my time. Thank you, Your Honors.
May it please the court, I need to address something that I strongly disagree with opposing counsel regarding, and that is his assertion that the idea of reputation, the evidence was admissible as reputation testimony was not argued in the briefs, was not argued below, and is being brought up for the first time in oral argument. That is simply not true. Page 23 of the initial brief says, and this is the first sentence of the argument under this third argument that's being raised, is that appellant Pitts should be permitted to introduce evidence of his lack of propensity for committing sexual battery either through testimony regarding his reputation for nonviolence with respect to sexual offenses or through testimony of other women that have dated him. That's the specific argument being raised in the direct appeal brief. It's the first sentence of the brief. It goes on to cite cases, in particular the Pino case, that talks about when reputation evidence is admissible. I quoted you before, but I'll repeat it just quickly. Defense counsel on page 376 argued to Judge Lewis, Mr. Pitt's reputation in high school was actually a reputation for nonviolence with respect to sexual offenses. That should be admissible to the jury. Judge Lewis, it just isn't. You can't do it by reputation. So the state's only response to my reputation argument is that it's being raised for the first time on appeal. They haven't cited a single case or made a single argument as to why it wouldn't be admissible. I've cited cases that say it's clearly admissible. For them to say that it's not properly in front of the court is simply not true.
I think the confusion may be about what particular evidence we're talking about. I mean, was there separate proffered evidence that went to reputation, or is the argument that the young woman who formerly dated him, that her testimony that she was not assaulted would speak to his reputation?
I think defense counsel at that point already proffered her testimony and is saying, I'm going to introduce this one way or another. And
But that's the only testimony that's been proffered, right?
It is the only testimony, but a proffer is not always necessary if the reason for what you're trying to introduce is clear to the judge and the judge says it's not coming in for that purpose. So defense counsel clearly informed the judge that I want to introduce this for the purpose of showing he had a good reputation, and Judge Lewis cuts him off and says it just isn't. It doesn't come in for reputation. So I submit that it's properly preserved. The state has not argued that it's not properly preserved. That issue is in front of this court. The state has absolutely no response to it. And for that reason alone, my client is entitled to a new trial so he can put on that evidence that he was seeking to put in that Judge Lewis erroneously said that he couldn't. Thank you.
Thank you, Mr. Efferman. All right, well, give these lawyers an opportunity to clear out, and then the next group can come up.